Hello, Constitutional Law class. Welcome to Unit 2. In Unit 1, we discussed the power of judicial review. As we discussed, even under a broad reading of judicial review, the court is not meant to serve a general governance function. The judicial power is limited to certain cases and controversies. It does not authorize the court to serve as a roving political ombudsman. This is an important limitation because justices of the Supreme Court are not elected representatives and hold lifetime tenure unless removed from office through an impeachment process. Nevertheless, the federal judiciary must possess the power to render binding judgments in certain classes of cases, or the Constitution itself will lack any bite. In contemporary jurisprudence, one of the key ways this tension is negotiated is through the rules of standing and related doctrines addressed in this unit. In the Federalist Papers number 78, Alexander Hamilton stressed the importance of insulating the judiciary from ordinary politics. The fact that judges are appointed rather than elected, and that they hold lifetime tenure subject only to impeachment for bad behavior, Hamilton noted, is certainly one of the most valuable of the modern improvements in the practice of government. In a monarchy, it is an excellent barrier to the despotism of the prince. In a republic, it is no less an excellent barrier to the encroachments and oppressions of the representative body. And it is the best expedient which can be devised in any government to secure a steady, upright, and impartial administration of the laws. At the same time, Hamilton argued, the inherent limitations on judicial power serve as a vital check on the judiciary. According to Hamilton, in a government in which they are separated from each other, the judiciary, from the nature of its functions, will always be the least dangerous to the political rights of the Constitution, because it will be least in a capacity to annoy or injure them. The executive not only dispenses the honors, but holds the sword of the community. The legislature not only commands the purse, but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or the wealth of society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive arm even for the efficacy of its judgments. In the Federalist number 80, Hamilton further discussed the specific kinds of cases the federal judiciary should be empowered to hear. There were state courts before the 1789 Constitution was drafted, of course. Here, Hamilton addresses why there is a need for separate federal courts. As you would expect, Hamilton's answer is rooted in his views about the need for a stronger federal government. He says that there ought always to be a constitutional method of giving efficacy to constitutional provisions. What, for instance, would avail restrictions on the authority of the state legislatures without some constitutional mode of enforcing the observance of them? The states, by the plan of the convention, are prohibited from doing a variety of things, some of which are incompatible with the interests of the Union, and others with the principles of good government. The imposition of duties on imported articles and the emission of paper money are specimens of each kind. No man of sense will believe that such prohibitions would be scrupulously regarded without some effectual power in the government to restrain or correct infractions of them. This power must either be a direct negative on the state laws or an authority in the federal courts to overrule such as might be in manifest contravention of the Articles of Union. Incidentally, Hamilton also explained in the Federalist number 78 that the appointment, rather than the election, of judges is important because relatively few people are truly qualified to serve as judges. In that explanation, Hamilton stressed a theme that should resonate with you as law students today. A voluminous code of laws is one of the inconveniences necessarily connected with the advantages of a free government. To avoid an arbitrary discretion in the courts, it is indispensable that they should be bound down by strict rules and precedents, which serve to define and point out their duty in every particular case that comes before them. And it will be readily conceived from the variety of controversies which grow out of the folly and wickedness of mankind, that the records of those precedents must unavoidably swell to a very considerable bulk, and must demand long and laborious study to acquire a competent knowledge of them.